Welcome to Litigation Nation. I'm your host, Danessa Watkins, here with my co-host, Jack Sanker. As a reminder, this is the show where we give you a wrap-up of the fun and interesting legal news from across the country. So, Jack, what do you have for us today?
A couple of things. We're going to start with putting this on everyone's radar. There's hearings that are upcoming before the U.S. Supreme Court regarding lower courts' abilities to issue national injunctions on federal actions. This has become kind of a political issue. You may have heard about this in the news with respect to the immigration policy and a couple of other examples you could think of coming out of the White House in the past couple of weeks. I'll be talking about that, as well as a couple of fun ones towards the end of the episode regarding the dragon lawyers out of Michigan, which some of you may have seen all over social media, and then another group of lawyers getting in hot water over the misuse of AI and drafting legal documents.
Always an AI issue. Okay, great. I'm going to cover the recent lawsuit filed against the cookie company Crumbl for their use of copyrighted music in their social media. As a note for our listeners, we are recording this episode remotely, as Jack and I are both traveling for depositions and work and whatnot. So apologies in advance if our audio is not as clean as normal. Please bear with us. So all that and more, here's what you need to know. All right, on to a cookie story. Jack, have you ever tried Crumbl cookies?
Of course, they deliver.
Oh my gosh, they're so good. Yes. So unfortunately, our good friends at Crumbl are being sued. They are out of Logan, Utah. So they're being sued in a Utah federal court by Warner Music Group, WMG. This lawsuit was just filed on April 22nd of 2025. So just about a week ago from our recording date here. And WMG is claiming copyright violations. So this company, it's actually made up of a bunch of different record groups. So like Atlantic Records, Bad Boy Records, among various others. And then Crumbl, their company operates currently at more than 1,000 locations across the country. I saw a note, I didn't look into it, so don't quote me on this, but it looks like they're looking for a buyer. I don't know if that has anything to do with this lawsuit or something they were pursuing earlier, but since they came out, I think they incorporated in like 2017. They've been very aggressive on the social media front. So that has been a huge marketing tool for them. And they put out a lot of videos on TikTok and Instagram, which has certainly been a real progression in their growth as a company. Latest stats I found were 9.8 million followers on TikTok and 6.1 million on Instagram. And what they're doing is building this brand by putting popular music promotions behind their content on these two platforms. And according to WMG, they are doing that without paying for the privilege of the use of those music rights. So they're claiming that Crumbl's investment in social media advertisements and the Crumbl videos in particular have been critical to their success, but they are not paying the rights to the artists and the publishers that they wouldn't be successful without, essentially. They've got, I would say, good marketing in that they pair songs like Blueberry Faygo by Lil Mosey to promote a blueberry cheesecake cookie. They have a Kentucky butter cake cookie that was promoted with the song Butter by BTS. All of these are mentioned in the lawsuit, as well as some of the popular artists through WMG whose music is allegedly being swiped. And that is Taylor Swift, Ariana Grande, Selena Gomez, Bruno Mars, Beyonce. So the heavy hitters for sure. Mm-hmm. Interesting to me was that apparently WMG sent a cease and desist letter to Crumbl almost exactly 2 years before they filed this lawsuit. And allegedly, Crumbl didn't respond to the cease and desist, but they did post a video on TikTok that stated, quote, "Legal said we can't use any trending audios," end quote. So clearly they received the cease and desist, they understood it, and then they continued to post infringing videos after that. WMG, in their complaint, they also mentioned previous lawsuits where Crumbl has gone after its competitors for trademark infringements. So the idea being, like, Crumbl understands this area of law, they understand the gravity of infringing on the rights of others, and yet here they are doing it themselves. So there are three different claims of infringement being brought. One is direct infringement, meaning Crumbl itself is putting out its brand with these videos that are copyright infringement. The second is contributory. So influencers of Crumbl are reposting these infringing posts. So it only essentially furthers the infringement and the reach of the harm that's being cast here. And then the third type is vicarious. So WMG is claiming that Crumbl is responsible for its influencer partners who they themselves are taking music that isn't copyrighted in order to promote Crumbl's brand. The idea being that Crumbl has the ability to control what these influencers are posting. They could, warn them not to use copyrighted materials that they don't have the rights for, or tell them to even take stuff down once they realize that there is a violation, and they are not doing that. So they should be held vicariously liable. Now, this is, a serious amount of money that they're asking for. It looks like they're asking for up to $150,000 per infringed work. They also want a permanent injunction, but they are estimating that there are 150 songs so far that they've infringed on. So we're looking at about $24 million without adding in legal fees.
Can I jump in? How is this different than using music on TikTok or Instagram that everyone else already does?
So yeah, I looked into this a little bit because it is an interesting issue, and obviously it's been an issue for a while. So I'm kind of surprised that we haven't seen more lawsuits like this. So it's a little bit tricky. So there are different licenses that are required for different types of users, content, and companies. Certain social media platforms, they will have licenses, obviously for with like Sony or Universal or Warner, and those licenses allow for everyday people to use it for their personal use.
Okay, so not commercial use then, I see.
Right. So that's why we're able to add songs to the, cute videos of our kids and whatnot. So you don't hear them, screaming. But once you cross that line and you're selling a product, promoting a brand even for influencers, which I'll get to in a moment, then certain platforms will have a commercial library. So there are going to be certain licenses that they've already acquired for you, and you can use those songs for commercial purposes, but without that separate license. And I have to admit, I've never, in like certain, using Instagram, for example, I've never seen some differentiation between, I'm going to use this song for commercial purposes. So I'm not totally sure how that works on the platform itself, but there are some commercial liberties that like TikTok or Instagram will allow for. How you find out, which songs fall into that, I'm not sure. But there's also, it's not universal, right? So, and this is where I was going to get into the influencer stuff. So we do represent influencer clients in my practice, and we have to warn them, just because you are promoting a product on Instagram that Instagram may have the license for, that song that's behind, your video of you carrying this purse, you can't just automatically share that to another platform, because that platform may not allow for that commercial use.
Mhm.
So you have to be careful on that front. Another thing that's come up in my practice is employees. You may not realize as an employer that your employee can be considered an influencer. So if they are promoting your brand online, like, day in the life of, whatever, a associate for Amiri, or, some company, and they're like pushing your products, even if you have a policy against that, you as an employer could find yourself getting wrapped up in a lawsuit, and you would have to prove that no, this employee was acting outside the scope of their employment, and yada yada. But it is something to be aware of for our employer listeners, to make sure you have sound policies on what your employees do with their social media, especially
Yeah.
just in particular when it involves your product that you're selling. Um, so yeah, I mean, $24 million lawsuit, the right to recover attorney's fees. I gotta imagine that they're gonna try to settle this, and we'll probably never hear about it again. But it's definitely, setting the bar going forward for the next lawsuit, I would say. I can't
Yeah.
imagine being
It's
like,
amazing that this wasn't something that was, I mean, Crumble's not a small company.
mm-hmm,
They, they have counsel. I'm sure they do.
mm-hmm,
So I'm just like, I don't know, they're, especially posting to Instagram is hilarious. To be like, oh, they told us we couldn't do this. Like, okay.
yeah,
That's very funny to me. But quite risky, to do that.
feels a
And
little reckless, yeah.
yeah,
Um, so well, the thing that came to my mind right off the bat, but now that I've looked into it, it is something totally different. It was, remember when Peloton got sued? Um, was it like, I think it was like
oh,
it was pre-pandemic.
for the music in their workout classes.
Yeah, yeah.
Oh,
I was wondering if that had any, connection, but it is like a totally different area. It's they're called synchronization rights, sync rights. And for them, that's an even more, like, it's very difficult to get that. You have to go to each publisher. So a song may have like 10 different publishers that all have rights to one song, and you have to get approval from all of them before you can use that song if you're like pairing it with a visual, like obviously Peloton is, their product is visual. So once you
mm,
pair that song with it, yeah, you have to have the rights of everyone. So, they've got like what, thousands of songs, and the whole point of it is that they stay up to date, and they're pushing the popular new music. So just imagine like their legal team and what they have to go through to be able to do that. It's pretty mind
yeah.
blowing.
Especially in this case, when according to Crumbl, they were advised not to do this, and they did it anyways.
Yeah.
I could
And
just like, I could see their in-house counsel just like hanging his head in his hands, like, oh, why'd you do
right.
this?
Well, and I haven't gone to their page, so I'm not sure like how many of these videos they have out. I guess the lawsuit says 159. That's not that much, like you couldn't, and that's
Yeah,
probably over the course of, I don't know. I mean,
couple,
sent
couple
a
years.
cease they sent a cease and desist 2 years ago. So yeah. I feel like they had the time to reach out and get the licenses they needed. But
If you're in a situation where your in-house counsel is telling you not to do something, and you think it's a great idea to use that as content, like, my lawyer told me I shouldn't do this. Isn't that funny?
yeah, like, here's a screenshot of my lawyer telling me,
Yeah, don't
cut it
don't
out.
don't don't do that. That's some free legal advice to the audience.
Yes, I will back that. I think we can give that advice.
Okay, so this is an issue that has not yet been argued in front of the Supreme Court, but it'll be something we go back to once we hear more about the arguments and whether there's a ruling. But putting this on everyone's radar now, the Supreme Court is going to hear the argument on 3 consolidated cases on May 15th regarding lower courts' abilities to issue nationwide injunctions over federal actions. The question of lower courts' ability to issue national injunctions against the implementation of national policy, usually an act of Congress or an executive action, is being argued before the Supreme Court on the 15th. The cases relate to the question of birthright citizenship under the 14th Amendment, which is frankly an issue for another episode. Don't get me started on that. But the issue on appeal is a narrow question of whether lower courts can issue nationwide injunctions on the implementation of federal policy, or whether their injunctions have to be limited to the specific claimants that are before the court. This is going to be heard before the Supreme Court on emergency applications. Oral arguments on emergency applications are pretty rare. And this has been a politicized issue lately, with the GOP kind of rank and files taking issue with lower courts' frequent blocking of national policy, everything from immigration orders to border security, things like that. And it's particularly relevant because there's a couple of high-profile cases that are going to be affected by this, as well as national policy and everything else. But also, there are some folks on the court that are sympathetic to the argument that the lower courts should not be able to issue these national injunctions. Specifically, Justice Gorsuch. In 2019, for example, he wrote, quote, "The real problem here is the increasingly common practice of trial courts ordering relief that transcends the cases before them." And later he went on, "Equitable remedies are meant to redress the injury sustained by a particular plaintiff in a particular lawsuit. But when a court goes further than that, ordering the government to take or not take some action with respect to those who are strangers to the suit, it is hard to see how the court could be acting in the judicial role of resolving cases and controversies. It has become increasingly apparent that this court must, at some point, confront these important objections to this increasingly widespread practice. Universal injunctions have little basis in traditional equitable practice."
Is the idea, sorry to cut you off, but is the idea that they're sort of, judges are crossing over into the legislative role?
Yeah, I like either that, and they're also stepping outside of their jurisdiction to resolve actual cases and controversy.
Right.
So, and by the way, the injunctions are typically being issued on constitutional grounds. So, for example, if I'll talk in a moment about an immigration example, and this was the Abrego Garcia case that we'll get into in a minute. But what courts the reason that people are upset about this is because a particular action by the federal government is found to be either in violation of federal law or in violation of the U.S. Constitution. And then, as it relates to the particular claimant that is before that court, if it's only one plaintiff, for example, the court will nonetheless issue an injunction that enjoins the federal government from pursuing that policy nationwide, on the grounds that the policy as a whole is unlawful for one reason or another. So despite the fact that it's only one claimant before the court, the policy itself is unlawful.
Interesting.
Yeah, and it's I'm not well enough steeped in the specific legal arguments on. I'm from Gorsuch's writing, you could see that he's priming it for like a standing argument,
right?
And a separation of powers argument as well. I can't really speak to that super intelligently. I could tell you that that this is an issue so much now because there have been, I think, roughly 200 or so injunctions that have been issued by lower courts against the White House and its most recent, a lot of its immigration, deportations, things like that, and they're frustrated with that. They don't like that, and so we don't have to get into the overall, political arc towards I would say demonizing the judiciary, which I think is happening. But that pendulum, I think, does swing both ways. But currently, like, there is the example of the Wisconsin judge who was just arrested by federal agents. And I actually, I don't know whether or not there's specific grounds for that, or whether it was, merited or not. I can't speak to that. I just don't know. It is shocking nonetheless,
Right.
that it happened, regardless of whether it should have or not. It's just like, whoa, you don't hear about that very often. So that's like the political background to it. And in the larger context, there is the case of Rodrigo Garcia, who is an individual from the state of Maryland, but originally from El Salvador. He's been here in the United States undocumented illegally for the past 14 years. He was deported to El Salvador, quote unquote, mistakenly, without following the kind of full deportation processes. He was supposed to have hearings on a couple of things that he had claimed political asylum for. For example, he said if he was deported back to El Salvador, he would be persecuted by certain gang factions or whatever. Again, not expressing an opinion on as to the merits of that or anything else, other than it is settled and it is clear that under federal law passed by Congress, before the deportation happens, there has to be hearings as to those matters. Period.
Yeah, due process. Yeah.
Yeah. And due process is a sliding scale. How much process is due depends on the person and the kind of category of individual. We know this. Immigrants, people that are here undocumented, things like that, are due less process than citizens. And I mean, that has always been the case. And that's like, you don't have to strain to see other examples of that. For example, children or people that are, mentally unfit for trial, or 100 other scenarios you could think of where the process that is prescribed by law to those individuals is less than, a mentally competent U.S. citizen, right?
Right.
But nonetheless, like, it is clear that some process was afforded to Garcia by federal law, and the administration, in so many words, admitted to the fact that they deported him while skirting those rules. And in doing so, they flew him off to El Salvador, and he's, by all accounts, currently sitting in one of those El Salvador like super max, like insane, hellish mega prisons.
Yeah.
And
have you seen the photos? It's like,
yeah, they
unreal.
look. It looks like hell. It
Yeah.
truly does. And that's one thing. A lower court ordered Garcia to be returned to the U.S. after this mistake in this skirting of process rules was found. The administration, in so many words, admitted that it violated those processes. This matter went up before the Supreme Court about 4 weeks ago, which ordered the White House to, quote unquote, facilitate the return of Garcia to undergo the proper deportation court proceedings. Now, it seems like, and what the White House and proponents of this policy have said is, look, he's going to go back, go through the court hearings, and then be deported anyways. Because, he was in violation of, XYZ immigration rules, and the hearings would be, kind of pro forma at that point anyways. Again, I don't know whether that's true or not, but that's one of the arguments they're throwing up in defense of these actions. What's interesting is the White House, Trump specifically, and the rest of the kind of foreign policy people in the White House have said that, well, Garcia is out of the country now. The court is ordering the president to enact foreign policy to go get him back from El Salvador. And the court cannot do that. The courts have no or little to no authority over presidential actions as it relates to foreign policy. And since he's no longer in the country, you can't order us to bring him back, even though, setting aside the fact that, yeah, we sent him there, mistakenly or without going through the proper hearings, which has, interesting externalities if you sit and think about it for a moment.
Yeah, serious concerns. Yeah.
Right. It's like, I mean, yes, he was, by all accounts, accused of being an illegal immigrant. I don't from what I've seen, that very much seems to be the case, and he very well may have ended up being deported anyways. But
I
the
thought, and I mean, we don't have to, because I certainly have not read up on all the facts in it, but I thought that he had been granted asylum, and that so long as he didn't, break the law or something, was that the issue with him? And then there was some accusation that he was part of
MS-13.
MS-13, and but there are people that are going to speak on his behalf, I think, that will say like, well, no, he just had an associate who was involved in it, or a cousin. I don't know. Again, I don't know the specific facts, but was that's this case, right?
I think so. To be honest, I get them confused because there's so many, and
I know it's
I
hard
can't
to keep track, but
I can't dwell on them all.
but either way, like the idea being, no matter whether you're born in this country, born somewhere else, granted asylum, there has to be some process before the government just ships you off to, especially a place where you fled from and were granted asylum from for your safety. So
well,
even if I'm just like making a bigger policy argument here for
oh yeah, yeah,
American,
yeah.
but even if it turns out that he gets brought back, goes through the process, and they find, well, yeah, we should have deported him. Fine. You're sending like a larger message though, that like we have rules here and we're going to follow those rules. And it's just interesting how quick sometimes people are like, oh, well, that's a waste of money. Well, okay, but imagine it's your loved one. Imagine it's your sister, your brother, it's you. Don't
Well,
you want to have that opportunity to like plead your case?
yeah, and also like the larger implication of, and this is kind of outside the scope of the upcoming Supreme Court hearings, but it's all related. Um, the larger issue of once you're shipped off to another country, the White House doesn't have to do anything to get you back.
Right? It's
Um,
like a loophole.
yeah, well, I mean, that's I think expressly what their position is like, aha, we got you there.
Hmm.
And you know, and like, sure, maybe you don't think that undocumented or illegal immigrants, should have this level of process or whatever. At which point, I would say, lobby, your Congress to change the laws in that regard. Or if you don't like how long that process takes, which I mean, I get it. It's there's the immigration courts are backed up to the gills. Seemingly people that want to come in legally aren't able to do it. People that are supposed to be deported legally aren't able to be done quickly because of the backlog and everything else. I mean, so much about the administration of justice in this country, in my opinion, boils down to lack of resources
Hmm.
for administering justice, meaning courts, judges, prosecutors, defenders, all those things, which if you doubled the amount of judges or whatever, you would see these things move faster, but you don't see people talking about that. The and I again, without getting too far into the weeds on this, if you could just be thrown off to another country without uh, process or whatever, say you're a green card holder, or even and by the way, green card holders have been being deported by the
Hmm.
government in recent weeks. Um, it's not so much you're being deported, that's one thing, right? Being deported back to your country of origin is one thing. What's happening here is uh, in El Salvador, he's being sentenced effectively to life in prison in, you know, in like the prison from the third Batman movie. But
Yeah.
that's like a whole where Bane comes from. That's
Yeah.
basically where they're going, and
Hmm.
they're going to go there and live the rest of their lives, which I imagine will be shortened dramatically by being there. So it's not so much as let's deport them back to their country, whatever. It's like we're going to condemn this person to like probably suffer and die
Hmm.
without due process. And
Right.
if you think that uh, the slope is not slippery enough to go from illegal immigrant to green card holder to maybe nationalized citizen
Hmm.
to on this question of birthright citizenship that is now also being working its way through the courts. If you were born here but your parents aren't American, are you in fact a citizen? or are you not under the 14th Amendment? I mean, that slope looks slippery enough to me where
Yep.
you could see chipping away at, normal citizenship rules.
Right.
Um, and like, I'm not trying to be alarmist or anything else, but if you give a mouse a cookie, it will.
Jack. Yeah.
Yeah,
Jack, we need to be alarmist at this point, I think.
yeah. I I
So
I I use the give a mouse a cookie argument in my um briefing practice fairly often, and it's because if you give a mouse a cookie, it's going to ask for a glass of milk.
yeah.
If you pry this door open a little bit, there's going to be a next step. Uh, so with respect to Garcia, I mean, again, without getting into a question of whether he should or shouldn't be deported, or whether deportation is appropriate in this context, or anything like that, you should be concerned that there's rules in place that were ostensibly put in place for a reason through the democratic process, by Congress to do this thing for one reason or another. Which, if you disagree with those laws, repeal them, change them, whatever you want to do. And the administration just says, you know what, we're going to just dump them in prison in El Salvador to die, which is the reality here, and you can't do anything about it. So this relates to, the larger outrage about national injunctions and whether Supreme Courts, or whether district courts, trial courts can issue those that are going to enjoin the federal government from doing X, Y, and Z. And I mean, in this case, government didn't care; they just did it anyways. Um,
So to go back to what the kind of like broader issue is here. So there was a court that found that the government is enjoined from deporting people of a certain citizenship class without due process. That was the injunction.
so the Garcia case, I understand that it was limited um, to him. So that's, I mean, this is
Okay.
this kind of story that I'm
Just
talking
an
about.
example. Yeah.
Yeah,
Gotcha.
but there are a dozen or so cases that have enjoined the government from doing certain types of deportations and certain types of immigration actions and everything else at a national level, and that's what everyone on that side of the fence is, complaining about. And
Got it.
and you know, I don't know. Again, on like regarding the standing issues, separation of powers issues, and all those things, that Supreme Court is going to, hear in a couple of weeks here. I don't know. There may be something there. That might be the case. Um, but let's not miss the forest from the trees here. The reason why it's all of a sudden an issue, and why people care about this issue all of a sudden, is because uh, the White House is being enjoined from carrying out these Garcia type deportations.
Mm-hmm.
That's the reason anyone cares right now. So don't, if you're thinking about this and you're like, well, maybe he was here illegally, and who cares? He's going to get deported anyways. You're missing the point. What
Yeah.
matters is, well, and same thing with the standing arguments with respect to the power to enjoin at a national level. You're missing the point. The reason why people care is because there are folks that want broader immigration enforcement and deportation, less rights for those going through that process, including up to, so far at least, green card holders. And at the same time, the same people are chipping away at birthright citizenship. So this is all part of a larger, you know, political and legal movement, if you will,
Mm-hmm.
to kind of change the way that we do things in that regard. And you could support that or not. That's fine, but I'm not so much interested in the nitty gritties of the specific arguments one way or the other, which I imagine the Supreme Court is going to focus on. They'll focus on standing, they'll focus on separation of powers, they'll focus on personal jurisdiction, those things. I am not so much interested in that as I am the larger ramifications. I should note, by the way, and if I've said this before, maybe Kevin cut this, but I should note that the Supreme Court did order the White House to bring the guy back. They said the word facilitate, and
Right.
and the word facilitate now is being litigated. Like, what does facilitate mean? And you're like, well,
Yeah.
we're not stopping him from coming back, I think, is a position that they're taking. They're like, he could come back. I mean, we're not telling him he can't, it's just, he just so happens to be in in the Bain prison. And well, nothing we could do about that now.
And they don't want to release him. So yeah. So what's
yeah,
nothing to do? Yeah.
and the president of El Salvador was in the United States like 2 or 3 weeks ago, and he was like, "Well, I'm not going to release him. The president says that he's part of a terrorist organization. Why would I let him out of prison?"
Oh my God.
So they could lock you away under a certain interpretation of this. They could lock you away and throw away the key as long as it's in a different country, and no one can do anything to get you out. So whether you think that that's I'm being chicken little here and arguing that the sky is falling or whatever, and whether you think that this administration would do something so brazen or not, maybe they would, maybe they wouldn't, but maybe someone would down the line. And
Yeah.
all the more
That's
reason,
what
yeah.
we need to remember, like that's how our system works, is we
Mhm.
set the precedent for the future. So that's why our law moves so slow typically
Right.
until now. But and not to like dumb it down, but I do think it's kind of important to think about like, so what is happening that is different from the norm. So like normally you would have a plaintiff come before you, say, this is against my constitutional rights, and the court may enjoin the government from acting against that individual, and then the government can appeal if they want to appeal or not, and everyone goes along with their lives. It seems like what's happening here, though, is the court is saying, not only am I enjoining the government from acting this way towards this particular individual, but all similarly situated individuals.
Yeah,
Is that,
or the specific policy, like if
or
there's
the policy? Yeah.
an executive order or something like that. Yeah.
And I don't see, I mean, I'm, because I always, I guess, resort back to state laws because this happens more often in that context where a new state provision will come out and then it'll get challenged as unconstitutional. And but that process, it still allows for the court to look at it like, is this unconstitutional on its face, or
Right.
is it unconstitutional in this specific instance of this
Right.
person? But they're allowed to make that decision.
Hmm.
And I get that it's a difference between state court and federal court, but that's how I kind of equate it, as like, now you have I would imagine U.S. district federal courts saying, no, this executive order is unconstitutional. To me, that seems like the same thing. Like, why wouldn't you be able to make that facial
I mean,
versus,
I think that they can, and but I think that um, I think that the issue, um, it's the grounds for issuing a preliminary or an emergency injunction, are the standards for issuing an injunction before there's a trial on the merits, um, are lower for a reason, typically. In the God, it's been a while since I've had to deal with this, so I don't have the specific factors in front of me, but there has to be a risk of irreparable harm, and there has to be a
Mhm.
substantial likelihood of success on the merits. So, if you were, for example, enjoined from collecting payments on something, as a result of like a contract dispute or whatever, or if you wanted to get an injunction in that regard, you're not going to succeed because like payments, the collection of money is fungible, which means you can go ahead and like collect your money later, or you can get your money from someone else or whatever. Like money is a fungible remedy. Whereas being deported to prison for the rest of your life is not. It's non-fungible. It's irreparable. If you go there, the harm you suffer is going to be something that can't be redressed with for example, money. So courts give greater leeway for preliminary injunctions, which are kind of extraordinary remedies because the court is ruling in such a way before there's a full hearing and a full trial on the merits. But it's because the risk of that harm is so serious that you can't wait to get to that point. And that's one of the things that will be addressed, I'm assuming, in this argument on the 15th is, has that process been abused by lower courts?
Right.
But again, whether those processes can or should be curtailed, whether district courts have expanded that their ability to do this, whether some district courts are abusing that one way or the other, keep in mind that that's not the reason why we're talking about this. We are talking about this because of what the administration wants to do and what it views as a hurdle to accomplishing those things. And that is, one of them is, preliminary injunctions, like full stop. So if you find yourself getting bogged down in the weeds on, I know the Supreme Court is going to do, you are missing the point. So we'll circle back on that when the arguments happen and when we have something more to report. But this type of thing is something that we'll keep our eye on. A couple of short, kind of fun stories here to close out the episode. The first one is, another instance of lawyers getting in trouble over misuse of AI. In particular, this is involving the CEO of MyPillow, Mike Lindell, who, if you don't know, is a bit of a crank. And he's kind of seemingly caught up in like really insane legal issues. This is involving the Dominion voting machine lawsuit. He was one of the folks that was, spreading conspiracy theories about the voting machines being, hacked or controlled to steal the election in 2020 from Donald Trump and all of that. Dominion has so far legally crushed its opponents in these lawsuits, including Fox News, Alex Jones, the whole gamut of those people that were tied up with that. Mike Lindell seems to be next on deck. So this is a defamation case regarding that. The reason he's in the headlines again is because his lawyers have been caught by the district court in some of their briefing. The district court's pointing out 30 different citations in the briefing that were either phony, miscitations, fake quotes, or just citations to cases that just flatly don't exist. Yeah. So, asking ChatGPT to write your brief and then not, checking it or anything else. Another instance of generative AI, hallucinating things that it thinks you want to hear. So presumably, hallucinating the existence of favorable case law because as the user, that's what you want. And despite the fact that case law doesn't exist. So the lawyers were hauled into court and they were kind of, after sheepishly being, questioned by the court, they admitted they used AI, didn't check before filing. Now I believe there's sanctions that are being weighed by the court. This is in addition to a long list of a couple examples that have made the national news. There were a couple of folks in Texas that have done this. We covered a few, I think way back in 2024, as lawyers have started to use this technology, many of whom are not using it either ethically or really smartly, and just kind of letting it write their briefs for them. And this is where they are. So another reminder, folks, if you are going to be using this technology, please check the work. And you shouldn't be relying on it, because every time that you open the news and read about this stuff, someone else is getting in trouble for it.
It's so interesting that the AI is like spitting back what it thinks you want to hear, because isn't that like, legal writing 101? Like you can't, like as an ethical matter, you can't present one side. Like if they're, I mean, you're obviously going to argue, but at the same time, like you can't mislead the court to believe that everything is one-sided. Like you have to admit when there are hurdles in your argument or in the law, and then you have to distinguish them.
Yeah, or you can't, make up cases that never happened.
Oh, well, that too, yeah.
Yeah, that's. I mean, from my perspective, like, yeah, it would be great if I could punch in, hey, find me, law that supports this position I'm taking in this lawsuit. It spits it out, and I could just, copy and paste that into a brief, and then bang, get the brief out that much quicker. Seems like we're quite far away from that, though. And, so if you're seeing any products out there, by the way, that are promising to be able to do that, a healthy level of skepticism is warranted.
For sure. Refreshing that judges are actually checking the case sites though. That's
Hey, at
good.
least the judge read the brief, right? That
Yeah,
is
love it.
not always happening. And then I will, and we could jump to the last one here, just because this is the one that like really tickled me throughout the week, and people had a lot of fun with. But Danessa, did you see the dragon lawyers, and did you see them on social media and like kind of the story floating around?
Literally couldn't miss it. Yes.
Oh my
Amazing.
God. We're gonna try to put the image in the show notes or put it out with this episode because it's so good. But um, there is a circuit court judge in the Western District of Michigan that's like lost patience with a firm there called Dragon Law PC, which has been filing documents in the courts with these colorful watermarks that are on each page. And the one that is that made it onto Twitter and kind of went viral is a on the front page of the complaint, and I believe on every subsequent page of the complaint, there is a full page watermark that is a let me describe the image. It's a giant purple cartoon dragon wearing a suit with its arms crossed. It looks very stern and very serious, but it is a purple dragon. And that apparently is the logo of this firm called Dragon Law PC. This is put on every page of their pleadings. And, the court, upon receiving this, I think appropriately responded with, like, what are you doing? It also kind of raises other issues, like, imagine what you're spending on ink here, assuming like there's some paper documents that get filed or whatever, or if the court wants to print this out, or if the opposing counsel wants to print it out and read it on the train or whatever, they got to print out this stupid dragon watermark. But I mean, setting aside that, like, for those of you who don't know, local courts have a lot of rules about formatting and what you can and can't do, and something that you file, like, down to the margins on the paper or the type or the size font or the type of font that you use, things like that are grounds for the court to strike or sanction a lawyer for disobeying them. Here, the court ruled, quote, use of this dragon logo is not only distracting, it's juvenile and impertinent. The court is not a cartoon. Accordingly, it is ordered that plaintiff's complaint is stricken. Plaintiff is directed to file an amended complaint containing the same allegations as the original complaint without the dragon cartoon. It is further ordered that plaintiff shall not file any other documents with the dragon cartoon or other inappropriate content. So, after this kind of went all over Twitter, people were having fun with it on social media. Some people went and looked at, the website for this firm. And I don't mean to drag, these poor lawyers here, but their website
I think it's already blown up. Yeah.
Their website is also hilarious. There's inexplicably there is a checkout mechanism at the top, so you can like add things to your cart. I have no idea.
What?
Yeah, it's like a Shopify type setup. Of course, front page website, giant dragon. Right away. We're letting you know we're the dragon lawyers. There, you've come to the right place. And then there's just like vague mention of like AI, like we use AI and so, but it's also been going on, by the way, for a couple of years now. This is not a new thing, and they've seemingly been getting away with this for a couple of years, and finally someone's dropping the hammer, I will see if the dragon lawyers are going to roll over on this, if they're going to fight for their right to include cartoon dragons in their filings, and if anything happens, we'll update you.
Oh my gosh, so interesting. Yeah, we need to find our own logo. I think we should bring this to Chicago.
Even like using like photos and things like that in filings, like some judges don't like that.
Right.
And like, but if you want to, like, for example, there's a scene of an accident and you have a picture of the accident and you want to cut and paste that into the complaint, like, which is I think more and more common now. But even sometimes the judge is like, no, don't do that. You could submit it as an attachment or an exhibit or whatever.
Mm-hmm.
So maybe they could get away with that. Is like, we are dragon lawyers, plaintiffs for lawyers. See Exhibit A, giant picture of dragon. All right, everyone, that's our show. As a reminder, you can listen to us everywhere that you get your podcasts: Apple Podcasts, Spotify, YouTube, wherever. We release new episodes every 2 weeks, and we will talk to you then.